Hi, this is Dan Smith. Welcome to today's podcast episode of Legal Scrubs. Today I'm going to be talking about covenants not to compete, and I'm going to list 5 important things that every new doctor or old doctor in Tennessee needs to know about covenants not to compete. First of all, let's talk about what a covenant not to compete is. Essentially, a covenant not to compete is a provision in an agreement. Typically, it would be found in an employment agreement between a practice and the doctor. This provision limits the doctor's ability to practice medicine within a certain geographic range and for a certain period of time after that doctor leaves the employment relationship with the practice. So, as an example, if a new doctor coming out of residency or coming out of a fellowship joins a private medical practice somewhere in Tennessee and is presented with an employment agreement, that doctor should look carefully at the provisions in it dealing with the covenant not to compete, because it might have for example, it might have a provision in the agreement that says that the doctor will not practice medicine in the county in which the practice is located for 2 years after he or she leaves that practice. That's a covenant not to compete. Now, what are the 5 things I mentioned that doctors need to know about covenants not to compete? Well, one is that you need to make sure that you're looking for them when you're reviewing an employment agreement that's presented to you. That goes without saying. But the first thing really is that covenants not to compete in Tennessee between a physician practice or a hospital and a physician, an employee physician, they are enforceable in Tennessee generally. Now, there's a lot of language in cases dealing with covenants not to compete that basically says that covenants not to compete are looked upon with disfavor. They're strictly construed. Uh, there's basically some language and opinions that would lead one to believe that maybe a particular covenant might not be enforceable because the policy is to allow free and fair competition in the professions or in business generally. But what you need to know as a doctor, number one, is that covenants not to compete are generally enforceable in Tennessee. Now, the second thing you need to know is that there is a statute in Tennessee that places some limitations on what can be in a covenant not to compete involving a physician. One is that one limitation, and this is item number two to know, is that there is a time limit on what a covenant not to compete can cover. Essentially, a covenant not to compete involving a physician in Tennessee cannot be any longer than 2 years. Now, the statute also provides a geographic limit on how large a geographic area the covenant not to compete can cover. That's also in the statute in Tennessee. That's item number three that you need to know. There's a geographic limit. The geographic limit in Tennessee is the greater of 10 miles from the practice site where you're working as a physician or the county in which your practice is located. So, for example, you could have a practice that is near the boundary of a particular county, and so a 10-mile limit going one direction or another might be greater than that county, or the geographic limit in the provision might just provide that you can't work while you're under the restriction in the county in which you're located. And then one also must know that um, uh, there's another wrinkle to this geographic limit that's included in the statute. Generally, it's 10 miles or the county, whichever is greater, but it is permissible for the employer to provide rather than a specific geographic limit of 10 miles or the county border of the county in which the practice is located. It can provide that the physician won't work at any of the facilities that the practice works at and has worked at during the time the physician is employed. So it might provide rather than 10 miles or the county, it might provide you can't work at XYZ hospital or XYZ clinic during the period of time in which you're under the restriction. So those are the first three things to know about. Number one, covenants not to compete are enforceable in Tennessee. Number two, there is a statute that provides a specific time limit, which is 2 years at the max. And number three, the covenant not to compete has a specific geographic limit, no greater than the county or 10 miles from this practice site, unless it provides that you can't work at a particular facility that you were working at or the practice was working at while you were employed. It can't have that. So those are the first three. Number four is even if you're under a covenant not to compete, because covenants not to compete essentially restrict trade, restrict competition, they're still subject to the general rules that courts look at when they're trying to determine whether a covenant not to compete is enforceable or not. And one of the requirements is that there must be a legitimate protectable interest, legitimate protectable business interest.
So what is a protectable business interest? A protectable business interest is one that under the public policy of the state, courts are willing to enforce covenants not to compete because the employer has done something to merit the protection that the covenant not to compete gives them under the contract. There are typically three different types of things that the employer can do to have a protectable business interest for a covenant not to compete in Tennessee. Number one, the employer can provide the employee with specialized training of some type. If the employer does that, then courts consider that because of that specialized training, the employer has a protectable business interest in enforcing that covenant not to compete. Another thing that the employer can do that results in the employer having a protectable business interest is providing the employee with access to certain confidential information of the employer. So, for example, if an employer makes confidential information, proprietary information available to the employee and the scope of the employee's employment with the employer, then because of that access to confidential information, courts will say, well, the employer has a protectable business interest in making sure that the employee, when he leaves or she leaves the practice, that they are not able to use that confidential information and compete with the employer, because that competition would be more than just straight fair competition, but unfair competition, because the employee would have access to that confidential information. So that's another way that an employer can gain a protectable business interest, is by providing confidential information to the employee. A third way that an employee can become that the employer can have a protectable business interest in enforcing a covenant not to compete is that the employee has become essentially what's called the face of the business or the face of the practice to its patients or customers. And because of that, then the employer has a right to enforce the covenant not to compete. Otherwise, the customers of a business or the patients of a practice, in looking at that employee who has left the practice as the face of the business, it would be a damaging situation to the employer if the employer could not enforce the covenant not to compete. So there's always a question about whether there's a legitimate protectable business interest in a situation in which there's a covenant not to compete. So if employer in a practice doesn't provide any specialized training to the doctors in their practice, and they don't provide access to confidential information of the practice, and that doctor is not really the face of the practice to the patients of the practice, then the doctor at least would have an argument that the covenant not to compete was not enforceable. Obviously, it would take, if there was a challenge to the covenant not to compete, it would likely play out in the courts, because the employer would likely want to enforce the covenant not to compete, and the employee would be in the position of having to raise the defense that the employer does not have a protectable business interest. Finally, the fifth thing that I want everyone to know about, all the doctors, new and old in the state, need to know that the FTC, the Federal Trade Commission, has proposed a new rule. They did this in 2023 that, if it goes into effect, would essentially ban all covenants not to compete in the United States. Now, at the present time, that rule is has not gone into effect. It's still at a point that the FTC has not adopted or promulgated that rule. It's just in the preliminary proposed state. So that is not the case at present. But in the coming year, let's say in 2024, it may be that the FTC will come out with a rule that might actually do away with covenants not to compete on a nationwide basis. If it does that, there's certainly going to be lots and lots of litigation about the validity of that rule. But just keep in the back of your mind that the FTC has proposed this rule, and it's not in effect, but later this year, 2024, it's very possible that the FTC will make a final determination about the validity of all covenants not to compete. Again, if it does that, then almost certainly the very next day, if not the same day, there are going to be legal challenges in court to that rule. So that's it. If you look and try to recap what we just talked about, number one, covenants not to compete in Tennessee are enforceable generally. Number two, the statute provides a time limit on covenants not to compete for doctors, which can't be more than 2 years. Number three, there's a geographic limit, which is generally 10 miles from the site of the practice or the county line, whichever is greater, unless the employer, in lieu of a geographic limit, puts a provision in there that prohibits the employed physician from working at certain facilities that have been worked at by the practice during the course of the physician's employment, such as a hospital. And number four, in order for a covenant not to compete to be enforceable in Tennessee, the employer must have a legitimate, protectable business interest, which is usually created by either specialized training, confidential information being provided to the employee, or the employee being the, quote, face of the practice or the business to the patients of the practice. And number five, just be aware that the FTC has proposed a rule that would ban all covenants not to compete. That rule is not in effect at the present time, but in 2024 there will likely be some more information coming out about what is going to happen with that FTC proposed rule. All right, that's it for today on Legal Scrubs. I hope this information is of help to you. Please let me know if there's anything I can do to provide any additional information on covenants not to compete for your practice. And until next time, we'll see you on Legal Scrubs.